Can a trustee sell property without all beneficiaries approving of that sale? Short answer is yes. A trustee does not need beneficiary approval to sell trust property, at least in most instances. However, a trustee who wants to avoid litigation and protect themselves would be wise to at least seek approval of the trust beneficiaries and, at a minimum, be able to substantiate why the property was sold and how that sale benefited the beneficiaries. Who has the legal title of the property owned by a trust? The trustee is the legal title holder of assets that belong to a trust. The trustee holds and manages trust property as a fiduciary for the benefit of the trust beneficiaries. While the trustee holds legal title to trust property, the trust beneficiaries hold equitable title as the beneficial owners of that property until the property is distributed to them, at which time title will be changed into their names. Does a trustee have power to sell property? Unless restricted by the specific terms of a trust document, a trustee has the power to sell or encumber trust property, and without the permission of the trust beneficiaries. As long as the trust allows it, and the trustee avoids self-dealing and conflicts of interest, the trustee can sell trust property to whomever he or she chooses, as long as it's sold for market value. Often trust disputes arise when a trustee sells property for what beneficiaries deem to be a submarket price. Similar problems can also arise if a trustee appears to be working for their own interests, such as selling property to themselves or another trust or company they own or manage. Even if the terms of the trust explicitly allow a sale to the trustee, transparency and avoiding self-dealing and conflicts of interest can go a long way to keeping trust beneficiaries happy. What happens when a trustee sells property? A trustee has a duty to make trust property productive and to avoid waste. What this means is that when a trustee sells trust property, they have a duty to reinvest the sale proceeds in a manner that is profitable to the trust for the ultimate benefit of the trust beneficiaries. To avoid disputes or legal challenges, a trustee should be transparent about the potential sale of trust property. Beneficiaries hate surprises, and selling a loved one's assets is a surprise sure to lead to a beneficiary taking action. To protect against a potential challenge, a trustee also should document his or her efforts to secure market value for any asset being sold. What this means is getting broker opinions of value, real estate appraisals, business valuations, art appraisals, etc. The values themselves should be documented, as well as the trustee's efforts to obtain those values, so the trustee can demonstrate to the beneficiaries that they took reasonable efforts to secure the best, highest prices for those assets. Of course, not all trustees do what they should, and if you believe a trustee breached their fiduciary duty by selling property below market value, is selling property that cannot or should not be sold, or if you're a trustee being accused of breaching your fiduciary duties, you should consult an experienced trust litigation attorney who can help you determine what your rights are, what your responsibilities are, so you can protect yourself. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation online at our website, rmolawyers.com. Thanks for watching.